Hello students, welcome back to SuperKalam. I hope your NCERT preparation, NCERT understanding is going good, and you all must be attempting MCQs because it is not just about reading NCERTs and watching the videos. It's also important that you test the knowledge. It's very important that you do these MCQs which we are specially making for you all, right? So besides studying, watching videos, you should do that also, right? So in this journey of SuperStart with NCERTs, I, Madhur, again welcome you to the next class, which will cover two important chapters from Polity NCERT, class 11th NCERT, Indian Constitution at Work. These two chapters are Judiciary and Philosophy of Constitution. Right? So let's start these two chapters and cover them in detail. So you must remember that in the last class on polity, I talked about legislature and executive in detail. And I also told you that judiciary is one of the organ of government besides legislature and executive. I also told you the legislature and executive works in an integrated fashion. For instance, prime minister. Prime minister is the part of legislature. He is the part of executive also. So they work in an integrated fashion. Now, what is this third organ, judiciary, all about? How it is structured? How in Indian Constitution the provision of judiciary is there, and why it is there? That is most important thing. Why is it is there? So why part I'll cover in the next slide. But first of all, I want to tell you that in India we have a very vibrant judicial apparatus, judicial institution. You can say that we have a single integrated system. Now, what does this mean? Single means judiciary is only one. That means you cannot say that subordinate courts are different, district courts are different, high courts are different, supreme courts are different. No, they work in an integrated fashion towards a one goal. See, you have to understand that this difference with respect to the federal nature of a state. So, for example, in India, we have union and we have states. They have very well defined functions, very different functions. For example, state works for law and order. One example, union works for international relations, right? So there is a little bit of defined jurisdiction for them. They are different. They do not interfere much. That's the feeling of federalism. But in case of judiciary, this whole system is integrated. That means Supreme Court, High Court, Subordinate Court, they all work for justice. You can go for your fundamental rights. If your fundamental rights are violated, you can go for High Court also. You can go to Supreme Court also. Any court you can go. So there is no differentiation. From a citizen's perspective, it is integrated. It is one. And Supreme Court is at the top. So that's the difference. It is an integrated judiciary. Whether if you want to go to judiciary against central government, for example, you can go to Supreme Court, you can go to High Court, you can also go to subordinate court. That's the integration. ऐसा नहीं है कि you can go to Supreme Court only against central government and you can go to High Court only against state government. No, these are integrated, right? Now I have to show you this integrated form of government in the slide in this chapter itself. So this is the structure of judiciary given, which you can clearly say the Supreme Court of the India is at the top. It heads it. Its decisions are binding on all courts below it. It can transfer judges of High Court. It can move cases from any court. You know, I told you about writ. So this is under writ of certiorari. It can transfer cases. So this is the overall function of Supreme Court. Similarly, High Court hear appeals against lower courts. It exercises control over lower courts. Similarly, we have district courts. Now, district courts basically functions at the level of district. Various courses, various criminal courses, civil cases they hear. And then we have subordinate courts. Now there are district courts, and at the district level, there's a very different hierarchy altogether. right? But in this chapter, we will focus more on Supreme Court and little bit on High Court as it is given in NCERT, right? So I hope the structure is clear. Supreme Court, High Court, and there are subordinate courts. Subordinate courts can be many. District court is a part of a subordinate judiciary. There can be Gram Nyayalayas also. There can be family courts also. So these all come under subordinate courts, right? So structure is clear to you. Now, as I told you, integrated judiciary means that all courts interpret and uphold constitutional law, right? This you should remember. Now, next is the why component, why judiciary is needed, right? And second is why it is independent in nature in India. I told you legislature and executive are very much clubbed, integrated, but judiciary functions very independently. Now there is a reason why judiciary functions independently. Why do we need independent judiciary? Right. Now in your NCERT itself, it's given very nicely. See, now why we need independent judiciary? To safeguard rights of individuals. If government or legislature is passing certain laws or doing something which is going against your rights, where you will go? You will go to judiciary. And if judiciary is independent, you will trust it. You will trust that it will not take sides of government. Uh, it will hear your grievances in an independent fashion, on merits, not on any nexus. That's why it safeguards rights of individuals. It settles disputes also. For example, there is dispute between states. There is dispute between center and state. Now, if center will settle this dispute, there will be a violation of principle of justice. A person cannot be lawyer or judge in his own case. That's why it is the judiciary independently which settle disputes. And it also ensures that individuals' rights, the checks are there, the constitutional limits which constitution has imposed on government are seen by judiciary. So because of this, because of a democratic sense, so all this boils down to democracy. In a democracy, no dictator can be there. Therefore, independent judiciary ensures that it checks everybody, it checks government. That's the importance of independent judiciary. So this is a line which has been taken from your NCERT. Independence ensures impartial decisions based on constitution, not politics. There is no nexus. It ensures, the judiciary ensures that there is no nexus. Your grievances are heard in constitutional fashion, in the spirit of justice. Now this is the need of independence. Now our constitution has very smartly ensured this independence also. How? There are a lot of provisions which are there. For example, appointment process is there. I'll cover in detail, but our appointment process of judges is such that executive or legislature do not have much say in that. The advice of Chief Justice of India or judiciary itself becomes very important in appointment. Therefore, executive cannot put its own people in judiciary. That's the appointment process. That's how independence is ensured. Second is there is a fixed tenure. There is a fixed tenure. For example, for a Supreme Court judge, 65 years pe they retire. For a High Court judge, 62 years pe they retire. Similarly, salary are also fixed, and salary cannot be changed during their term. For example, if I become this judge of High Court, then throughout my tenure, my salary cannot be decreased. It can be increased, but it cannot be terminated. It cannot be decreased. Why? Because this is a safeguard given to judges, and also this salary of judges is charged on consolidated fund of India. That means Parliament during budget discussions cannot even discuss on this matter, on the matter of salaries. It has to sorry, Parliament can discuss it, but it cannot disapprove it. It has to pass. It is charged. It has to be passed. Parliament can discuss, but it cannot change it. Then the removal process is very difficult. Till now, no judge has been removed yet. This is very difficult removal process. I'll discuss this in next slide. And our constitution itself separates judiciary from executive. Tell me which article says about it. Article, which article of Constitution says that executive should be separated from judiciary? So our Constitution itself puts uh, that uh, opinion, right? Now, I hope you have understood the meaning of independence and the uh, principles as well as the provisions which ensure this independence. Now, the next thing is I will. So these facts are not given very directly in your NCERT, but these are important from a prelims perspective. That's why I'll cover this in a brief detail. Now, appointment of judges. You must be knowing that Supreme Court's strength currently is of 34 judges. Out of these 34, one is Chief Justice of India. And these judges are appointed by President. Although they are appointed by President, what Article 124 says that they should be appointed by President on the advice of certain judges. For example, CGI is appointed on the should be appointed on the advice of judges, which President seeks for. And other judges of High Court should be other judges of Supreme Court should be appointed on the basis of advice of Chief Justice of India as well. So basically, President is and in third there was a judicial case, third judge's case, which said that advice of judges or Chief Justice of India in this case is mandatory. It is not it is not optional for President. President has to appoint it. So you should, in the same way, for a High Court judge, also President only appoints. President seeks the advice of those judges he may seek fit for. So here also advice of judges is essential. Now, as I told you in third judge's case, the advice has become compulsory. Advice has become compulsory and advice cannot be ignored. Cannot be ignored. And recently you must have heard that new Chief Justice of India has been appointed. Now, new Chief Justice of India has been appointed after his predecessor recommended his name. That's why the role of judiciary becomes very important in appointment. President gives the final signature and the final go ahead, but it's on the opinion of judiciary itself. So that's how there's an independence also ensured, both with respect to Supreme Court judges and High Court judges. Both are appointed by President on the advice of judges. Next is removal. Now, removal process is very strict. There is a provision in the Constitution in Article 124 itself, and also for a detailed provision, government or legislature has come with Judges Inquiry Act for a detailed uh, provision of removal. Now, this Judges Inquiry Act, what does it do is, it has a proper procedure there. Now, the removal of a judge is basically the motion is introduced in Parliament. Now, what Parliament do is Parliament discusses it, and Parliament, both houses separately. Remember this: both houses separately has to pass the proposal to remove a judge with a two-third majority. Special majority is needed. That's why it's become difficult for any government to remove it, because government hardly have two-third majority. If they have two-third majority in Lok Sabha, it's difficult to have it in Rajya Sabha. Therefore, it is ensured that the opinion of opposition, smaller parties, is also taken in consideration while removal, and that becomes very difficult. But recently, what happened? There was a judge, Yashwant Verma, sorry. There was a judge called Yashwant Verma, and basically there were cases of corruption against him because some kind of cash notes were found in his home. So government now is very seriously taking this action. Government is in the upcoming monsoon session, which is starting in July itself. In this upcoming session, it is expected that the government will very seriously consider his removal process, and many opposition parties have also supported it in a way. So we will see how it goes, whether we will have a first judge removed through this process or not. But the whole point is that removal is very difficult to do. Then there are qualifications involved. How what are the qualifications? Now, for a Supreme Court judge and a High Court judge, there are some certain differences in qualification. Like for a Supreme Court judge, he should be a citizen of India, right? Then one of these, either he should be a judge of High Court for 5 years, or several High Courts in succession, or can be a lawyer for 10 years, or he can be a distinguished jurist also, right? So a person to be appointed by Supreme Court should be a citizen of India, and one of these conditions should also be fulfilled. In the same way, for High Court, he should be a citizen of India again. Here, conditions are a bit different. He should be a lawyer in High Court for 10 years or several High Courts, or he should be a member of lower judicial. He should be a judicial officer for 10 years. Here you should note that there is no principle or no provision of distinguished jurist in High Court qualification. This you should remember. Now, tenure, I already told you, for a high court judge it is 62 years, and for a Supreme Court judge it is 65 years. That's why our Chief Justice, the current Chief Justice, he is set to retire in just few months, because he will be of 65 years now. Right. So I hope this is clear. This is a very basic things about appointment, about removal, about meaning of judicial independence, about why there is a judiciary. Now we will come on very specific functions of judiciary, the powers of judiciary, and we will here limit ourselves to Supreme Court as per NCERT, although this can be seen for lower judiciary also and high courts also. So first we will check is first rather we will let's see the NCERT book itself. NCERT has given very nicely the jurisdiction of Supreme Court. So Supreme Court, he has many type of cases. One is the original jurisdiction. Now, original jurisdiction means these cases can be heard by Supreme Court itself. This is the original function. Means a High Court cannot hear these types of cases. What are these types of cases? If there's a dispute between union and a state or various states, then directly that state, that union, that government can go to Supreme Court. One example here is of Tamil Nadu. Now Tamil Nadu went to Supreme Court because it cited apprehensions with respect to NEET bill. It had certain disputes with respect to NEET with center. So that's why it directly went to Supreme Court. Then there is appellate jurisdiction. Appellate is driven from a word called appeal. Now, these are the cases which were heard by lower judiciary, whether a High Court or a lower judiciary, but because of appeal, someone appealed, one of the person who is involved in these cases, he appealed about that case. He is not satisfied with the ruling of High Court, and therefore he appealed in Supreme Court. So this can be in a civil case also, in criminal case also, in constitutional cases also. Now, one such appeal was done in the Ram Janmabhoomi case. So many of the parties in Ram Janmabhoomi case were not satisfied with the ruling of High Court, so they appealed the matter in Supreme Court. So this is the appellate jurisdiction. Then there is advisory jurisdiction. Advisory means President of India can seek advice on certain legal and constitutional matters from Supreme Court. That is advisory jurisdiction. Then there is writ. Now, writ jurisdiction, I already told you in the rights chapter, there are many types of writ: habeas corpus, mandamus, prohibition, certiorari, quo warranto, to protect fundamental rights. Now, if fundamental rights of any citizen are violated, he can directly go to Supreme Court, and Supreme Court will issue these rights. So this is also one of the power of Supreme Court. Then there is other special powers of Supreme Court. Now there is one thing called special leave petition. Even if some case shouldn't go to Supreme Court directly, if you are giving a special leave petition, Supreme Court can hear that case. For example, if there is a case with respect to a small case with respect to any violation, and you should go to High Court or a lower court for this, but you thought that this is a very big thing and you can directly go to Supreme Court. If Supreme Court admits it through special leave petition, you can directly go to that. So therefore, it can grant a special leave to an appeal from any judgment or matter passed by any court in the territory of India. This is a special power. So this is the jurisdiction of Supreme Court. You can go through it. I just want to tell you one current affairs example. See, that's how you connect current affairs with your NCERT static or maybe Lakshmikant static here. These books tell you about advisory jurisdiction, appellate, writ, etc. But recently, President of India has seeked the advisory jurisdiction of Supreme Court. Basically, there was a governor's case in which Supreme Court gave direction to the center. The center should ensure, or the president rather in specific, should ensure that the bills which are reserved for president's assent should be returned to the legislature, state legislature, in a time-bound manner. Supreme Court has given this ruling, and now President of India has sought Supreme Court advisory on a larger context, that how this kind of ruling should be implemented, what are the legal causes involved here. So very detailed, I think 14 15 pointers questions which our honorable president has asked. So this is the advisory jurisdiction which is used by President of India, and these are the basically the constitutional articles which you can see. Now, the powers of Supreme Court, the jurisdiction of Supreme Court, we discussed. Now, as I previously told you, that Supreme Court checks the government. That's why independence of judiciary is important. And there are few elements, few options through which this check is done. This is known as judicial review and activism. Now, with the word itself, we will understand judicial review means a review of something by judiciary. Judicial activism, it means a very active review, going beyond a particular point in reviewing something. Now this I will explain to you with examples. Now the basic framework of judicial review and activism is that judiciary can strike down laws that violate constitution. Now judiciary is the defender of constitution. It ensures that constitution is respected by people, by legislature, by executive. So whenever it see that anything violative of constitution is there, whether it is any law which is violating the constitution, it will strike it down. That is done through the process of judicial review and judicial activism. Now the difference is, in judicial review, Supreme Court just checks the constitutionality, that whether a particular law was in line with constitution or not. But in activism, it goes beyond that. It not just checks the constitutionality, it also says that what should be the ultimate action. It do not just give a judgment, but it also tells what needs to be done. I'll give you one example. For example, there was a case with respect to harassment, sexual harassment at workplaces. Now the case went to Supreme Court. Now Supreme Court issued guidelines, famously known as Vishaka guidelines. Now this is in a way a lawmaking process by Supreme Court. Supreme Court is issuing guidelines, so it is like Supreme Court is making a law. So this is not the function of Supreme Court. So in this case, Supreme Court went beyond its power, its jurisdiction. Why? To do justice. So sometimes judiciary, Supreme Court or High Court has to go beyond its defined functions in order to do justice, because justice is the ultimate end. That's how Supreme Court do judicial activism, very actively doing justice, going even beyond its defined mandate. But in judicial review, you do not. It remain in the defined permit only. Now, there is one very prominent example of judicial review. You must be knowing about National Judicial Appointments Committee. There was this thing. Basically, The government came with a National Judicial Appointment Commission. Why? Because government wanted that the existing collegial system of appointment should be done away with, and there should be a commission, Judicial Appointment Commission, which should also have members from executive, and it should have power of appointments. Now, what judiciary did? Judiciary striked it down. Why? Because judiciary said if executive members are involved in such commission, it will violate the independence of judiciary. And judiciary independence cannot be violated. Judiciary independence is a very soul of constitution. Or we also use the term called basic structure of constitution. I will cover this. So therefore, Supreme Court through judicial review striked it down. So I hope judicial review in activism is clear. Now there is one more thing, PIL, public interest litigation. Now sometimes, for example, there is a group of citizens who is affected by certain developmental projects of government. There is a livelihood crisis for them. Now someone, me and you, or someone in a group can on behalf of these affected communities can go to Supreme Court and say that this community is being harmed, the right to live of this community is being harmed by the government. I am giving you PIL, I am filing this PIL, please hear this case. So PIL are public interest litigation. If any person or any group is going to judiciary, to high court or Supreme Court for a larger public interest, that can be done through public interest litigation. Now it is also a way of judicial review and activism, because here the Supreme Court reviews the government actions, the legislative actions. So that is also one thing which you should know. Now, as I told you in last slide, there is one thing called basic structure doctrine. Now tell me, Parliament can do amendments to Constitution, right? Parliament can do amendments. Now there can be a time where there are so many amendments that the basic essence of Constitution, which our forefathers made, are also amended. There can be a case, but Supreme Court ensured that this is not done. The basic essence, the basic soul, some foundational values which are there in Constitution should never be amended, should never change. So that's how Supreme Court came with a basic structure doctrine. So basic structure is that part of the Constitution. Basic structure is that part of the Constitution which is the soul, which is the essence of Constitution and shouldn't be changed. So therefore, this was not mentioned in the basic structure thing, is not mentioned in our constitution. It was given by Supreme Court in Keshavanand Bharti case. In Keshavanand Bharti case, Supreme Court was hearing the various cases with respect to right of property, which the government was dealing with. Supreme Court said the government can change the constitution. It's fine, government change the constitution, it amend the constitution, but it should not amend certain features of the constitution which are sole. That is, it should not amend basic structure. And what is this basic structure? Judiciary independence is a basic structure because it is the soul of constitution. Free and fair elections are basics of our constitution. In the same way, sovereignty of country, socialism principles, secularism, these all are the basic soul of constitution and shouldn't be amended. So Keshavanand Bharti case said that. And how it is important? It has preserved democracy. Otherwise, government or any party out of popular beliefs can have amended the constitution, the basis of constitution. So that has been avoided, right? So that's the importance of basic structure doctrine. Now, although Supreme Court or judiciary is a very prominent institution, it is very trustworthy institution in India. A person may not trust the government, but they generally trust the Supreme Court or a High Court. Why? Because they believe that the judiciary will do justice. But there are issues with respect to judiciary itself also, which we should know, and it is also important from a mains examination point of view. One thing you should remember at is judges are unelected but powerful. So see, if any unelected person is given power, it is going against the principle of democracy. So if you are giving such power to an unelected person, then there should be transparency and accountability, right? There should be transparency, there should be ethical conduct, but there are certain issues. For example, there are delays. Around 5 crore cases are pending in judiciary as of now. Who is accountable for that? Judiciary infrastructure is very poor, especially in lower judiciary. There are not even basic toilets available. Many computer facilities are also not available. So who is responsible for that? Now accountability. Now there are so many of delays. Who is accountable for that? If judiciary would have been elected, then people would have voted it, not voted for it. So in that way, accountability could have been ensured. But here, the judiciary is not elected. So who will and how it will be accountability will be ensured? Then many a time judiciary even overreach, as I told you in the last slide. Sometimes it makes laws, which is the function of parliament. Isn't it a overreach? There are criticisms for that also. So therefore, these are certain criticism and for which there are reforms needed. What reform is needed? There should be a better appointment process. Currently, judges are appointed by themselves. So there is no check. If you are appointing yourself, who will check you? So therefore, there should be a better process of appointment. NJEC was one of the process, but we have to come up with a process where the judicial independence is not compromised. Then infrastructure we have to boost. Government and judiciary together are working. There is one project called e-courts project where expansion of technology is being done. For example, AI being used for cases handling. Then there is a use of technology in order to also for the trial of the case. For example, during COVID-19, online trials were also done. And there should be some ethical code also, because see, there are limits. One cannot criticize judiciary. One cannot uh, you know make it responsible from external means. Therefore, internally only, through ethics, through their own judiciary ethics, they should come forward and ensure that they are taking responsibility, accountability of their delays, of their these cases, like this corruption case which was going on against one of the judge. So that is important. Then there is other thing which should be promoted, which is alternate dispute redressal. Alternate dispute redressal is, see, for example, if there are small cases of some rivalry, for example, petty offenses, then one should not go to court directly. One should try to address them through discussions. That is alternate dispute redressal. So basically, mediation, discussion, these all are the techniques through which these cases can be stopped from going to judiciary, and these are addressed at an initial point itself. And when you do this, you avoid adding one more case in 5 crore delayed cases. And lok adalats are already there, which is basically organizing alternate dispute redressal, but it has to be strengthened because they are not very regular. They lack facilities. They are concentrated in few areas. They are not concentrated in, say, for example, in a very backward area or very hinterlands of the country. So that's why this should be improved. This is also comes under reforms which are needed by us, right? So this is all about judiciary. So what we understood in this chapter was why we need judiciary, why we need independent judiciary, how judiciary is structured in India, appointment, removal, how it happens, what are the powers, the four basic things we understood: the original jurisdiction, appellate jurisdiction, writ jurisdiction, and advisory jurisdiction. We also understood through recent phenomena, recent cases, newses, where this advisory jurisdiction was used. In the same way, removal of judges is also in news. Then we understood about judicial review and judicial activism, PILs, issues with respect to judiciary, and how we can reform it. So this is your chapter which gets completed here. So now we will cover aspects from chapter number 10. Chapter number tells about philosophy of constitution. Now it is very abstract. You should know the importance of this chapter from the perspective that there are many abstract things asked by UPSC. Meaning of a state. It can even ask meaning of philosophy, fraternity. It can ask meaning of socialism, secularism. Now these have very, very, very distinct meaning in case of India. That's why understanding this philosophy of constitution is very important. Now the first question is, what is this philosophy? Now, philosophy of something, if we say in a very layman term, it is basically the idea, the essence, the feel about something. So constitutional philosophy is the idea behind our constitution. What is the basic, fabric or basic ideas, principles, norms which our constitution promotes. Now, when we talk about constitution philosophy, one thing which should come to your mind is preamble of Indian Constitution. Preamble is basically the first page, the preface of the Indian Constitution, and it is said that preamble moves with the Constitution. It runs with the Constitution of India. That means preamble reflects the feeling, the essence of Constitution. That's the importance of preamble. That's why if you want to understand the philosophy of whole constitution, just reflect upon our preamble. That way you will be able to understand the basic norms and values which are important for our constitution. Preamble, in fact, it is also known as the mirror of Indian constitution. That's why it gives you a mirror of Indian constitution, right? So we will understand the basic principles which are given in preamble. There are a few key terms which are important you should understand. The meaning of sovereign. Sovereign means, in simple terms, means independent. You are not dependent on anybody. For example, if government or legislature is doing certain activity, they are making law, they are passing certain rule, they are not directed by a foreign country like UK or US. They are not directed by any other thing. They are independent on their own. That is the meaning of sovereign. Opposite of sovereign is dominion status. Now, if India would have been a dominion status, it would have been guided by UK. That's the opposite. Second is socialist. Now, socialism in Indian context is very different form of socialism. It is a Gandhian form of socialism, which says that we as a community should live together. We should ensure that the benefit is given even to the Antyodaya, the last person in the mile. That's the socialism. And for this perspective, we should follow a trusteeship model. That means the rich should give some contribution so that a poor can get certain benefits. That is the basic essence of socialism. Then secular, I'll discuss its meaning in detail, but secularism in simple terms means that freedom of religion is there as well as equal protection of religion by government is there. Democratic simple terms, universal adult franchise, that people elect the government. It's the people who are more powerful, Janta Janardan, which we say. Republic. Now, republic, to understand the meaning of republic, you have to understand the meaning of monarch. Now, in a monarchy, for example, UK, the head of the state is king or the queen, who basically become head as per their hereditary. This is the family whose members can only become head of the state. But in case of India, the president is elected, although indirectly elected, but elected. And you never know who will be the next president of India. It's the people who decide. People through their parliament decides. That's why it's elected. That's why we are republic in nature. Now, these are the basic essence of Indian state. Indian state is sovereign, socialist, secular, democratic, and republic. Now, there are few values which guide Indian state. For example, legislature, executive, judiciary, civil servants, even our independent bodies like Election Commission of India, CAG, etc. All are guided by few basic principles, few values: justice, liberty, equality, fraternity. Even you, as an aspirant, as an aspirant, also as a civic person, also, and also in future, if you become the civil servant, you also have to ensure that these values are enshrined in your functioning. What are these values? First is justice. Justice means fairness, that the order should be fair. For example, the preamble talks about economic, political, social justice. There are different angles of justice which are given in preamble. Social justice is more related to that everyone in the society is equal. There is no untouchability. There is no, exploitation of each other. Then economic justice means that all opportunities are there for everybody, even for poor, for rich, equal type of employment opportunities are there. So that's the meaning of justice. Liberty, simple terms, means freedom. In Article 19, you must have got the essence of it. I have a freedom of speech, you have a freedom of speech expression, practicing any profession, moving in a different part of the country, settling anywhere. So this is the liberty which you get. Now, liberty in Indian sense does not mean extreme liberty. There are certain reasonable restrictions, which I already told you in Article 19. Then equality. Equality has two meaning in Indian context. everybody is equal. For example, President of India or a common man, they are equal. Second meaning is equal treatment of law. That means if you have done a similar crime or you are at a similar situation, you will be seen as a similar individual. That means, say for similar crime, there is a similar type of punishment. That is equality. You are equal in yourself and also equal in the eye of law. Next is fraternity. Now, India is very diverse country. Now, this diversity shouldn't translate into any type of division. So for that, it is essential that despite diversity, we are one. And for this, the feeling of fraternity is important. Now, because of this fraternity, feeling of fraternity, a person from maybe Punjab and Kerala, they both believe in one thing, Indian Constitution, the essence of Indian Constitution, the feeling of oneness. A person from the East, a person from the West, oneness is there. That is a fraternity, brotherhood, togetherness. That is the essence. So these values basically should guide you. They guide all the institutions which are established by our constitution. Now, few philosophies we should study in detail. Now, I told you about individual freedom and social justice both. Freedom is individual's freedom, that I have right to do anything which I want. Social justice is that if a person is backward, then government has a role to help him. Now, it can be claimed that if social justice is there, where government is intervening your freedom in your freedom, how can you achieve individual freedom? It may appear that these two terms are contradictory, but they are not so. Why? Until and unless poor person knows his worth, poor person is educated, how can he enjoy his freedom? If a poor person is not educated, have poor health, he cannot work, he cannot go in good employment. If he cannot get employment and good money, how can he exercise his freedom? That's why these are integrated. You should always understand that in Indian context, freedom and social justice are integrated. Taxation, taxing an individual is example. Now, taxing one, you may say that it compromises your financial freedom, but no, the taxes which we pay they go for social justice, for helping people. For example, Manrega in food security, etc. So that's the essence of integration of these two elements, freedom and social justice. So you must always think in integrated fashion here. The next is respect for diversity and minority. This I already told you, fundamental rights chapter, that article 25 to 28 and article 29 and 30 also, they talks about respecting the religious freedom, linguistic freedom, culture. So all type of minorities should be protected. Secularism I will cover in next slide, so let's wait for it. Universal adult franchise. Now this is also the political philosophy. Why? Because it was not very easy to give voting rights to everyone. When our constitution was being made, our literacy rate was hardly 20%. How an illiterate person can be given rights? Many have questioned it, but we did it. Why? Because we believed in their wisdom. That's why this system of vote, this symbols, party symbols, election symbols, it came from that only. It was a solution to the illiteracy which was there, because you may not read, but you can identify the party with a symbol. But you know despite all these difficulties of illiteracy, large population sector, our philosophy was strong, that we have to give rights to common man. That's why we gave it. Federalism is also a philosophy. Federalism philosophy means some powers state will have, some powers center will have. There will be some power distribution at the local level, so that you know like day-to-day activities are handled by the local governments. Why to worry the central government about it? Central government should focus on big things, international affairs, defense, economy overall, right? These are the basic philosophies which are there: freedom, justice, diversity, secularism. So this you should know. It's given in your NCERT in detail. Now, as I promised about Indian secularism, now Indian secularism is very different. In the West, secularism means freedom as well as complete separation of state from religion. So state do not interfere in any way with the religion. But in India, there is a difference. It is a principled distance. You have freedom, but state can intervene. For example, in the name of religion, there used to be untouchability. Dalits were not allowed in the temple. But that is not correct from the perspective of individual freedom and social justice, which I told you in the last slide. So in that case, government can intervene. Government can say that or everyone is allowed in temple. So that is basically sometimes government can interfere in religion. Why? For overall justice. In the same way, triple talaq government banned. Why? Because it was going against women. It was going against their freedom. So in India, there is a principal distance. In normal situations, government will not intervene in a religion, but to protect equality and justice, it may, uh, you know, come and intervene. So that's the meaning. So principal distance allowed state to intervene in religion to protect equality and justice. And if you have read Article 25, which I told you in the last to last class, Article 25 talks about three reasonable restrictions: morality, public order, etc. Why? Because of the same reason. If any religion is compromising morality, the government will interfere. No total separation. And state may fund minority schools. See, to protect minorities, there is special attention which needs to be done. So state may fund minority schools also. Madrasas are in many states, they are funded by, they are given some kind of support by the state government. So it is there. So there is a principal distance. A state, as per its wisdom, as per constitutional obligations, will protect the religion and also interfere sometimes in them. Now, our constitution, these philosophies are there, but there are some criticism also, which are this is given in chapter 10 of NCERT. Constitution is very lengthy, very interpretive. Lot of jargons are used. Then Constitutional Assembly, which made it, was unrepresentative. Why? Because it was indirectly elected by provincial assemblies. I told you in the first chapter that is also a criticism. Without universal adult franchise, you are electing a assembly which is giving universal adult franchise. So it is a paradox. That is the criticism which is given. Next is it is borrowed. It has borrowed a lot of features. For example, it has borrowed parliamentary system. It has borrowed from Government of India Act, from US Constitution. So that is the thing. Centralized idea. I'll discuss in next class. The federalism in India is a little bit tilted in the favor of center. So where the states will stand, why you are not giving so powerful power to state like in USA? That is a criticism. Then socio-economic rights, that is DPSPs are not justiciable. Now, for violation of your social and economic rights, if you are not able to go to court, how you will ensure that these rights are implemented? That is a criticism, right? So this is the criticism of constitution overall, right? So this philosophy chapter basically tells you that there are some ideals which we should follow, and we should remember the meaning of secularism, socialism. These are very contextual. You should understand them in Indian context and should not copy them from Western context. And that's how you understand the constitution overall, right? So this was the chapter. Now I will take few questions. This I already told you. See, after this chapter, it is very important that you attempt MCQs, and I request you all that watching the video, first comment you will do on the video after watching it, that I have completed this video. Second comment you will do on the video after you do the MCQs and the mains question. Very small targets we have given, hardly 1.5 hours. You should complete it, right? Now, I can show you few questions, prelims question from this chapter. Let's maybe take judiciary only, Supreme Court. Yes. I think this question we earlier discussed also, writ of prohibition. So this you can check. We can see this question. With reference to Constitution of India, consider the following statements. No high court shall have the jurisdiction to declare any central law to be constitutionally invalid. Now I told you, India has an integrated judiciary. Even high court can declare central laws as invalid. So no high court, this is extreme statement, this is false. High courts can declare state central laws as unconstitutional. An amendment to the constitution cannot be called into question by the Supreme Court. Now, Supreme Court do judicial review. It has to ensure that all the laws, all the amendments are aligned with the basic structure. So, cannot be called? No, it can be called. Both are false. So none of the above are. You can see the this explanation. And also I request you to do a lot of PYQs also here. I will give you both links of PYQs as well as MCQs as well as a main question. So do them and definitely write to us. It's very important that we are doing this initiative. You are also taking part in it so that you are reading it properly. Day wise day, if you cover it now, one day, like we are covering it, you will be able to have a lot of good understanding about NCERT. So I request you all to do this, and all the best.